Hello everyone, this is your host Urvashi Chauhan. Welcome back to another episode of Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Delhi High Court, which today issued notice on the plea moved by Chief Minister Arvind Kejriwal seeking bail in the CBI case related to the alleged liquor policy scam. Kejriwal is in judicial custody in the corruption and money laundering cases related to the alleged scam. He was remanded to CBI custody for 3 days on 26th June by vacation judge Amitabh Rawat, observing that the arrest at this stage could not be said to be illegal. Special counsel D.P. Singh, representing CBI, today told the court that the grounds raised in the bail plea as well as the plea challenging Kejriwal's arrest were identical and there was an alternative remedy available with the Chief Minister, that is to first approach the trial court for bail. Senior advocate Vikram Chaudhary, appearing for Kejriwal, contended that since the trial court, while remanding Kejriwal, had observed that Section 41A of CRPC was not violated, it would be a futile exercise to approach the Sessions Court. Justice Neena Bansal Krishna issued notice and has sought a response from the CBI. The matter has been listed for hearing on 17th July, when Kejriwal's plea challenging his arrest is also listed. Stay tuned. In another update, the Delhi High Court has significantly observed that WhatsApp conversations cannot be read as evidence without there being a proper certificate as mandated under the Evidence Act. Justice Subramaniam Prasad was dealing with a plea moved by Dell International Services India Private Limited, challenging an order passed by the Delhi State Consumer Dispute Redressal Commission, which upheld the District Commission's order that refused to take on record its written statement on the ground that it was filed beyond the period of limitation. In 2022, a consumer named Adil Firoz filed a complaint against Dell before the District Commission. Dell International filed a screenshot of a conversation between it and Firoz to demonstrate that the entire copy of the complaint, along with all the annexures, was not received by it and it was only handed over to its counsel before the District Commission on 31st January 2023. Dell then filed an application seeking condonation of 7-day delay in filing their written statement. The District Commission did not condone the delay and held that Dell's application for condonation of delay of 7 days in filing the written statement was not bona fide. So Dell approached the Delhi High Court. The High Court has now rejected the plea, stating that WhatsApp conversation screenshots could not be considered in a writ petition under Article 226 of the Constitution, as there was no evidence that they were submitted to the State Commission. The court further noted that Dell claimed it had not received all documents with the summons, even though a complete set was served. Since Dell's written statement was only filed on 31st January last year, the court found no error in District Commission's refusal to excuse the delay. Consequently, the writ petition was dismissed. And now let me tell you that the central government has filed an affidavit in the Supreme Court opposing cancellation of the NEET undergraduate 2024 exam. The government has said that it is not a rational step to scrap the entire exam in the absence of any proof of large-scale breach of confidentiality. Stating that it is committed towards the conduct of all competitive examinations in a fair and transparent manner, the ministry assured the court that stern action will be taken against the criminals if it is found that the confidentiality of the papers has been compromised. The Union Ministry further stated that regarding the alleged instances of impersonation, cheating, and malpractices in the exam, the CBI has been asked to carry out a comprehensive investigation. It also informed the court that a high-level committee has been constituted to suggest measures for effective, smooth, and transparent conduct of the examinations by the National Testing Agency. The committee has started its deliberations and has invited suggestions from the public on reform measures. The ministry has further told the court that the law to deal with cheating and paper leaks of public examinations, that is, the Public Examinations Prevention of Unfair Means Act 2024, has been brought into operation. As you know that on 8th July, the Supreme Court is set to hear the batch of petitions challenging the alleged malpractices and irregularities in the NEET-UG 2024 examination conducted by the NTA. Stay tuned. You know that the Supreme Court last year had refused to grant legal recognition for queer marriages in India, saying that it is a matter for the legislature to decide. However, all the judges on the bench agreed that the Union of India, as per its earlier statement, shall constitute a committee to examine the rights and entitlements of persons in queer union without legal recognition of their relationship as a marriage. Post this, several review petitions were filed faulting the judgment for not affording any legal protection to queer couples despite acknowledging the discrimination faced by them. It has been argued that this amounts to abdication of the court's duty to uphold and protect fundamental rights. It has also been argued that the judgment suffers from errors apparent on the face of the record, as is self-contradictory and manifestly unjust. The court recognizes that the petitioner's fundamental rights are being violated by the state through discrimination, but fails to take the logical next step of prohibiting this discrimination. The petitions seeking review of the judgment are now listed before the Supreme Court on 10th July. Notably, the review petitions will be considered by a new bench composition since two judges of the previous 5-judge bench which delivered the judgment, namely Justices Sanjay Kishan Kaul and S. Ravindra Bhatt, have since retired. So now Justices Sanjeev Khanna and B.V. Nagratna replace the retired members of the bench. The other judges are Chief Justice of India D.Y. Chandrachud, Justices Hima Kohli and P.S. Narasimha. Senior journalist Rajat Sharma today moved an application before the Delhi High Court alleging that X, formerly Twitter, and Congress leaders Ragini Nayak, Jairam Ramesh and Pawan Kheda disobeyed the court order directing them to remove defamatory tweets posted against him. The defamation suit here was filed after Congress leaders alleged that Rajat Sharma used abusive language on air during a show on the election result day. Last month, a coordinate bench of the High Court ordered the Congress leaders as well as X to remove the social media posts within 7 days in terms of the intermediary guidelines. Today, senior advocate Rajiv Nair, appearing for Sharma, told the court that the 3 Congress leaders have not yet complied with the order despite communications being written to them. He submitted that X also did not comply with the order and filed an appeal before the division bench, but as no stay was granted and it was asked to comply with the order. Senior advocate Raj Shekhar Rao appeared for X and said that the social media platform had complied with the order as of late evening of 3rd July. However, Nair said that the compliance was partial as the viewing of the post has been disabled within India but can be viewed outside India. He submitted that since in the facts of the case, the impugned tweets were uploaded by the Congress leaders with an IP address within India, they ought to have been disabled on a global basis. Justice Manmeet Pritam Singh Arora issued notice in the application filed by Sharma and sought response of X and the Congress leaders. The court has granted 2 weeks' time to X and Congress leaders to file their replies and further 2 weeks' time for filing of rejoinder, if any. In a landmark decision, the Odisha High Court has held that a woman employee who attains motherhood through surrogacy is also entitled to avail the benefit of maternity leave, as it is not only beneficial for the concerned woman, but also needed for a healthy rearing of the newborn. In this case, the petitioner, a joint director at Gopa Bandhu Academy, applied for maternity leave from October 2018 to April 2019, after becoming a mother through surrogacy. She then requested earned leave until September 2019. However, the Finance Department's Undersecretary questioned the validity of the leave under current rules, noting the absence of provisions for leave in cases of surrogacy. Aggrieved by this, the petitioner approached the High Court. The single bench of Justice Sanjeev Kumar Panigrahi noted that under Odisha Service Code, a woman employee is entitled to avail 180 days of maternity leave. Such benefit is also extended to the female employees who attain motherhood through adoption of a child up to 1 year of age. But strikingly, a similar provision is absent in case of women attaining motherhood through surrogacy. The court referred to various judgments of the High Courts and the Supreme Court, which held that because surrogacy has been recognized by the Parliament by enacting the Assisted Reproductive Technology Regulations Act of 2021, a woman cannot be denied maternity leave for begetting child through surrogacy. So the court has directed the state to grant 180 days of maternity leave to the petitioner in this case, and also ordered to incorporate in the rules a provision for providing maternity leave to commissioning mothers so as to provide equal treatment to children born through surrogacy among other mothers. And lastly, the Karnataka High Court today issued notice on a bail petition moved by suspended Janata Dal secular leader Prajwal Ravanna, who is accused of rape and sexual assault in 2 cases. A single-judge bench of Justice Krishna S. Dikshit issued notice and directed the special investigation team probing the cases against him to file its reply. The SIT is investigating 3 cases registered against Prajwal, and he is presently in the judicial custody. The SIT had arrested Prajwal at the Bengaluru airport on his arrival from Germany in May this year. If you remember, before the Lok Sabha elections, videos went viral showing women being sexually assaulted allegedly by Prajwal. After casting his vote, he had moved out of India. The Karnataka State Commission for Women chief wrote to the state government seeking action be taken, following which the government formed a special investigation team which is now probing the case. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.